that intermeddling, that is dealing with the property of a dead person, is not cast on the stone. The law sometimes provides for exceptional circumstances when the court can overlook certain provisions and justify the decision that the court has given. We are looking at the succession issue. Now we are looking at the succession of another minister of President Kibaki, John Joseph Kamotho, the Secretary General of Kanu, the face of Kanu, the former Minister for Education, the man who was the face of Kanu in Mount Kenya region. Remember, President Moi was not being voted from Mount Kenya region, but his loyal lieutenant, JJ Kamotho, was the pillar there. This is succession court number 1096 of 2017. It was decided July 18, 2022. What does it say? The deceased John Joseph Kamotho died without a will in December 6, 2014 in a hospital in South Africa. He left his widow, Eunice Wamboi Kamotho, and 3 children, Charles Gidhi, James Mwai Kamotho, and Marianne Nyokabi Kamotho, and David Waweru Kamotho. The administrators of the estate of the deceased, an issue arose. Paragraph 3. One of the properties in the estate of the deceased is townhouse. You know where townhouse in Nairobi. That is townhouse number 7. The deceased and the first applicant are the registered owners of that property as tenants in common. So there was a dispute about a property that was owned by JJ Kamotho. In the dispute, the sons, paragraph 3, it is clear from a replying affidavit by the respondent who has opposed the application that even before making the application, the first applicant had on March 17 entered into an agreement to sell the property to Eric Murunga and Joy Kobia for Kenya shillings 82 million. They received a deposit of Kenya shillings 8.2 million, leaving a balance of 73,800,000. The respondents state that they are opposed to this piecemeal distribution of the estate and want the parties to wait for the confirmation of the grant when the entire estate shall be distributed. Their case is that although the first applicant, their mother, is sick and on a wheelchair for a long period, she has a comprehensive medical cover and that therefore no medical bills could be outstanding. This is a question of intermeddling. The will, there was no will. The property succession has been completed, but they have entered into a will and they have received 10%. Judge, under Muchelule is now saying, under section 83B2 of the law of succession, Cap 160, it is illegal for an administrator to sell any immovable property belonging to the deceased before the grant is confirmed. Here, the first applicant began to sell the property in question before the grant was confirmed. She did not seek the court's authority before engaging in this transaction. She has come to court after she has begun the transaction. Be it as it may, I consider that the first applicant was married to the deceased for many years. This can be evidenced by the fact that the children were born 48 and 37 years of age when the case was filed in 2017. The first applicant was then 71 years old. She is now 76 years old. She is sickly and on a wheelchair. In all the property left by the deceased, including the house, there is certainly an element of her contribution to the acquisition and development. The couple educated their children who are now pursuing professional careers. They will certainly each benefit from the estate when the grant is finally confirmed. What did the judge do? I also considered that this apparently straightforward case has remained unresolved from 2017. 2017. Largely because of lack of the understanding between the first applicant and the respondents. There is no telling whether, come the day of hearing of the application for confirmation, there won't be a twist of some kind. It is quite unfortunate that the first applicant, who was once normal but is now confined to a wheelchair, says that she needs to buy a specialized vehicle to ferry her around. But the respondents say that according to them, that is not necessary. That must be very painful for the first applicant. Kamotho's wife wants to sell the property they acquired with his husband to buy a specialized vehicle to take her around. Her children are saying that the vehicle is not necessary. Clearly, this woman had intermeddled into the land. And the children are saying this is intermeddling. This is a serious question before Justice Muchelule. What will Muchelule say? Paragraph 8. Considering the special circumstances for this case, and I repeat, considering the special circumstances of this case, and given the powers donated to this court under Section 47 of the Act and Rule 73 of the Probate and Administration Rules, I allow the sale and order that half of the proceeds of the sale shall be shared equally among the children of the deceased, while the other half shall absolutely go to the wife of the deceased. This provision shall be taken into account when disputing the rest of the estate of the deceased, dated and delivered at Nairobi this 18th day of July 2022 by Justice Aggrey Muchelule, Judge of the High Court, now the Judge of the Supreme Court. What is the importance of this matter? That intermeddling, that is dealing with the property of a dead person, is not cast on the stone. Special circumstances can militate against the offense under Section 45 of the Law of Succession. What is this? JJ Kamotho died. His wife is over 75 years. She's sick. The only property available to sell is one. If she waits until succession is complete, she'll die. She needs urgent medical condition. Justice Muchelule invoked Article Section 47 of the Law of Succession Act and said, I have the power to save life. I have the power to interpret the law in a manner that saves life. Justice Muchelule ordered the property to be sold, half of the property, half of the value to be given to the children, and half to their mother. How painful is it for a mother to get into this situation? The children you gave birth to, the children you educated, the children you took care of, don't want you to sell the property you contributed with your husband so that you get medical attention. A bold judge, Justice Muchelule, stood and ordered the property to be sold and be taken to the woman for treatment. So Wakili Omari brings it that the law sometimes provides for exceptional circumstances when the court can overlook certain provisions and justify the decision that the court has given. Those are the stories of the big men during Moi time. They also have challenges. Succession has challenges. Wakili Dan Omari bringing it the way it is. How many have we done?